Meta, YouTube, TikTok. Three of the most powerful companies on the planet are sitting in a Los Angeles courtroom right now. And the charge? That they knew their apps were destroying children's mental health, and they said absolutely nothing. This case is being compared to the lawsuits that brought big tobacco to its knees in the 1990s. And if the plaintiffs win, every app on your phone changes forever. My name is The Bench Report, and today we're going inside the courtroom for the case that could reshape the entire internet. Let's get into it. To understand why this case is so significant, you need to know how we got here. For years, parents, teachers, and mental health professionals have been sounding the alarm about what social media is doing to young people. Rising anxiety, depression, eating disorders, suicide rates climbing among teenagers. And the question everyone kept asking was, did these companies know? Well, in 2021, a Facebook whistleblower named Frances Haugen walked out of Meta's offices with thousands of internal documents. What those documents showed was damning. Facebook's own research concluded that Instagram was harmful to teenage girls, particularly around body image and mental health. They knew, and they kept it internal. That moment cracked the door open, and now an avalanche of lawsuits from parents, families, and school districts across the country have pushed that door wide open. They all point to the same thing. These platforms didn't just host harmful content. They engineered their products to be as addictive as possible, and they aimed that product directly at children. That is the heart of what is now being argued in a Los Angeles courtroom, and it is one of the most consequential legal battles in the history of the internet. Now here's where it gets interesting from a legal standpoint, and I want to break this down clearly because this is the part most people miss. For decades, social media companies have hidden behind something called Section 230. If you've never heard of that term, here's all you need to know. Section 230 is a law passed in 1996 that essentially says internet platforms cannot be held legally responsible for content that other people post on their sites. It was designed to protect the early internet and allow platforms to grow without being buried in lawsuits every time a user posted something harmful. And it worked. For 30 years, every time someone tried to sue Facebook, Twitter, or YouTube over harmful content, those companies pointed to Section 230, and the cases were thrown out. But here's the thing. The plaintiffs in this case are not suing them for the content. Read that again. They are not going after the posts, the videos, or the comments. They are going after the product design itself. The algorithms, the infinite scroll, the notification systems engineered to keep you glued to the screen, the features specifically built to make the app feel impossible to put down. That is a completely different legal argument. And Section 230 does not protect product design. Think of it this way. If a car manufacturer makes a car with faulty brakes and someone gets hurt, you don't sue the person who drove the car into them. You sue the manufacturer for making a defective product. That is exactly the argument being made here. These platforms, the plaintiffs say, are defective products that were designed to cause harm. If the court agrees with that framing, Section 230 becomes irrelevant, and that changes everything. So what are Meta, YouTube, and TikTok actually saying in their defense? Their legal teams are arguing that the problem isn't their product design. The problem is the content that third parties post on their platforms. In other words, they're saying, we just built the stage. We can't control what people perform on it. It's a clever argument. But here's why it's running into trouble in court. The plaintiffs have evidence, including the internal documents from Meta, showing that these companies actively studied how their design features affected young users. They ran tests, they saw the results, and then they made a business decision to keep those features in place because engagement numbers went up. That's the difference between being unaware of a problem and knowing about it. Awareness changes the legal calculus entirely. You can argue you didn't know your product was harmful. It's much harder to argue that when your own internal research is sitting in front of a jury. On top of that, the scale of this lawsuit is unlike anything we've seen before. This isn't one family suing one company. This is being described as one of the first of several major cases in 2026 alone, with comparisons being drawn to how Big Tobacco was taken down not by one lawsuit, but by a coordinated wave of them that eventually became impossible to defend against. The companies have billions of dollars and armies of lawyers, but the plaintiffs have documents, and in court, documents tend to win. Let's talk about what a loss actually looks like for these companies, because the ripple effects go far beyond a fine. First, money. We are talking about potential damages in the billions. School districts, families, and state governments are all part of this wave of litigation. If the court sets a precedent that product design can be held liable for mental health harm, every single pending lawsuit gets stronger overnight. Second, the algorithms change. If courts rule that infinite scroll, autoplay, and addictive notification systems are legally defective features, these companies would be forced to redesign the core mechanics of how their platforms work. The version of Instagram or TikTok you use today could look completely different within a few years. Third, and this is the big one, age verification becomes unavoidable. Right now, these platforms technically ban users under 13, but enforcement is basically non-existent. A ruling against them could force real, verified age gates that actually work, which means the entire business model these platforms have built around young audiences gets disrupted. And fourth, every other app is watching. Gaming companies, streaming platforms. Anyone whose product is designed to maximize time on screen is paying very close attention to this courtroom right now. Because if Meta loses, they're next. This is not a case about social media. This is a case about whether the technology industry can be held accountable the same way every other industry already is. The verdict in this case won't just affect 3 tech companies. It affects every app on your phone, every platform your kids use, and every business built on keeping your attention as long as possible. I'll be covering every major development in this trial right here on the Bench Report. If you want to know what happens next, subscribe and hit the bell so you don't miss it. And drop in the comments below. Do you think Meta and the others knew what they were doing? Let me know where you stand. This is the Bench Report. Court is adjourned.